Manu can take that.
Okay, Koiti Umtata is a public interest litigation individual. I think one of the things that the public needs to understand is that any of us can institute proceedings before our courts, but not all proceedings that any other person can be able to institute. Okiya Umtata specializes on matters public interest, matters that touch on bread and butter, and I think that is the reason why he has been allowed to practice. And if you've bothered to check, you will find that Okiya files petitions. And whereas an advocate who's admitted and practicing law files petitions too, they also file what we call plaints and different documents, of course, in a court of law. But Okiya cannot file to represent you on a commercial matter. He can only file a petition before the High Court. And the Constitution of Kenya 2010 gives the public the leverage to approach the High Court, especially on public interest matters. Okiya cannot practice in the magistrates' courts because they don't interpret the Constitution. He only files matters that actually seek to interpret the Constitution. So for that, the Constitution allows them to do that, from the High Court to the Court of Appeal to the Supreme Court on matters that are public interest in nature. And that touch on a public interest question, and that does not involve receiving. So I don't think he receives instructions from anyone to file those matters.
What qualifies as public interest?
What qualifies as public interest? I will give an example of decisions that have been made by the president through executive order, for instance. You remember during the former regime, the Law Society was in court challenging executive orders to transfer judicial functions from the judiciary to ministries. There was the Kenya Meat Commission matter, transferring of the Kenya Meat Commission, the forest. There are so many questions of law that qualify as public interest in nature as opposed to commercial in nature, where there is someone who needs to actually gain from a transaction going wrong. For instance, a contract. Okiya cannot actually go to court and challenge contractual issues against, of course, between parties or Kenyans. So that is the difference as between a public interest.
Do I hear you to be saying that matters that lean very heavily towards what you call public good?
Yes.
But are not necessarily commercial in nature or criminal or anything else?
Yes.
That alone specifically,
which
therefore means that it's something that revolves around the interpretation of the Constitution on that same matter.
Yes.
That's it.
Yes.
Yeah, actually, what happens is that, there's a document known as the Constitution of Kenya.
Okay, that one.
So the Constitution of Kenya contains what lawyers and what the Constitution itself calls the Bill of Rights. The Bill of Rights are rights which members of the public have against the state. So the same Constitution says any person can move to court and protect the Bill of Rights. For example, the right to privacy. If the government is intercepting telecommunication information unlawfully, they're intervening on your privacy. So Okiya Umtata, as a person who is authorized by the Constitution, can go to court and file a petition to protect the rights of the members of the public from violation by government. And he doesn't need to be an advocate. It is any person. What he can't do, what Okiya Umtata can do, is that he can file a case under his own name. And he has done brilliantly in terms of just protecting the public interest. But he files under his own name.
As Okiya Umtata.
As Okiya Umtata. And the Constitution allows him. And he appears in court in person. He cannot send an advocate to appear for him. If he does that, then he must cease appearing and appoint an advocate to represent him. So that's what happens. So Okiya Umtata has been filing public interest cases against the state. You will never see him in a commercial dispute because then where is the public interest?
Brayo was appearing on behalf of other people.
No, Brian, what he did was wrong. He was, one is that he stole the identity of a qualified advocate and then put that in pleadings.
Oh dear.
Yeah. Pleadings. Number two is that then he purports to appear in court, and from our interactions with documentation, one is that he appeared in court about 2-3 times only.
Okay.
Two is that he purported to be an advocate. in one of the clips which is there online, he says, I appear for so and so. You know, that's a very, very serious issue. That's why the DPP the other day ordered the Inspector General to investigate. Because it's a crime for you to purport to appear, yet you are not a qualified advocate.
I was going to ask, what kind of offense are we looking at?
Yeah,
here?
it's a criminal offense.
When this happens, so that's one part of it.
Yeah,
but then there's the other side of it where, again, the loss, the commercial loss, the resource loss that could happen as a result of somebody then posing as somebody else. So what kind of offenses are we looking at here?
There are about actually 5 offenses that this Brian is being investigated by the National Police Service. One is identity theft. You cannot purport to be someone, then you go online, then you take that person's identity. There's a real Brian who works at the state law office, who Brian stole his identity. That's a major criminal offense. Number 2, under the Advocates Act, you cannot appear, purport to appear as an advocate without having been qualified. So that's another offense which the Advocates Act creates. And then under the Penal Code, even the documents he prepared, uttering a false document. You prepare a document. Yes. Yeah. You prepare a false document, then you utter it to a judicial officer, purporting that to be a genuine document. That's a crime he has committed. So Brian is in trouble. Let him surrender. Let Sonko surrender him to the DCI as soon as possible so that he records a statement for purpose of prosecution. Because at the Law Society of Kenya level, advocates, we are really concerned about, he even comes out and does a Twitter post mocking us. We can't allow that. The position is that, we can't allow him mocking us. The position is that he's not an advocate. He's committed a criminal offense. Let him surrender himself to DCI as soon as possible so that he can be investigated through a due process. Let him be taken to court, and then he will plead, and then the state will prove charges against him. Because where he is, it is really very serious for you to act as an advocate, yet you are not qualified.
Can we clear up some cloudy issues here?
Yeah.
You talk about the fact that he then did appear in court a couple of times, and then the weight that it bore on that case, I think, is very important. And if you're going to ask yourself, then what were the outcomes of those particular cases where this identity theft took place, where purporting to obtain something in the presence of a judicial officer, etc., etc. What weight does it bear on those cases? Did it bear on those cases?
Yeah, let me clarify something first. Brian, contrary to the misinformation on Twitter, Brian has not won a single case.
Okay.
Yeah, winning a case is a process. Yeah, I think this is just by some Twitter folks who just jump on it as a leisure story, then they propagate, and then it's picked up by the mainstream. Brian has not won a single case in court.
All right.
But we confirm that he has appeared or purported to appear in some cases. What happens is that if you file a pleading and you're not qualified, and that pleading is in a case, so the court has an obligation then to strike out those pleadings from the file. And if you are a party then who hired Brian, who is not a qualified, then you must go to the drawing board and then hire a proper lawyer, because everything that you filed, everything that you filed in court will be struck out. The proceedings where he appeared, and if I am for the DPP, and he appeared in a criminal case, I will apply to strike out those proceedings, because they are nullity. You cannot have a person who is not qualified purporting to represent an accused person, or even to appear on record. So everything that he said, and it was recorded, it's then struck out from the record of the court. So those are the consequences for you appearing in court as a masquerader.
What happens to the person whom they were representing?
I don't think whether this gentleman was representing anyone. I think, if you look at the video that is circulating, he appeared in Maina Njenga's case in court. He just showed up, and I think there's one of our colleague in the DPP who actually had a conversation with him initially. And obviously you can't stop people from coming to court. We have trainee lawyers who are doing internships and all that, so you will assume that probably these are students. But when you take your feet and stand up and start addressing court. He said, I'm on record.
Yes.
But he never mentioned, I'm on record for who? Because
Was
you
he
are
on
on record
record
for someone, and you have to have written instructions. Actually, good practice is that actually a client has to give you written instructions.
Written instructions, yeah.
So
That
in
you
this
have come on
particular
record.
case,
Yes.
was he on record?
He entered on record, because you see what we refer as on record is that if the judge starts writing, he will ask your names, and you will mention your names, and you will say, I'm so and so, I'm on record for so and so.
Yes.
I think from the video and out of that euphoria, the gentleman stood up and said, I'm equally on record. Because if you realize, some of these cases have quite a number of lawyers, and some seniors come with their junior colleagues in office to participate in those proceedings as part of learning. So it's not difficult for the court to actually take that quorum. But again, you purporting now to say that you're on record and addressing court, and then later on it's discovered that actually you are not an advocate in the first place, or you didn't get instructions. It is a professional offense. It's not even a professional, because it's not even a professional in the first place. It's a quack. And so therefore, even the punishment that is given to advocates who are not active in practice is not given to him, because it doesn't qualify, doesn't have the LLB degree
And the complainant is not
diploma.
The complainant, remember, is the LSK.
Yeah.
So the offense which he has committed is purporting to appear, and the complainant is the Law Society of Kenya. Yeah.
Which is the regulator of the
The
profession.
regulator
Yes.
of the profession.
Yes. Yeah.
Umechezwa hapa bana.
So, contrary to the public opinion, as Peter
Mpatieni
stated,
senior counsel.
there is
No, he's
no
a criminal.
26 cases, and you see we have what we call in law citation.
Yeah.
What citation? What are these cases people are talking about? And I think most of the determinations made by the judiciary are posted in the Kenya law reports. And obviously, if you have determined a single case to finality, it takes a lot of time. And I think hearing a case from zero to the end to judgment, it's a process in itself.
It can take up to a year, actually.
And the gentleman indicates he's told an identity of someone who was admitted in 2022. It's not possible.
How can you win
practically
26
possible
cases
to win
within
26
a year?
cases
It's
within
impossible.
a year. It's
Ourselves,
not
we are established advocates, but you can't win 26 cases in a year. It's impossible, yeah.
You know, gentlemen, as you're saying, there are very many masqueraders in very many of the professions in Kenya.
Yeah.
I mean, we had the case of somebody who performed surgeries
A doctor, yeah.
as a doctor in a public hospital, yet he was not.
And the
qualified as a
policeman
doctor.
who was a
We
senior
have somebody who
assistant.
is a senior police officer who has never been employed as a police officer, and so on and so forth. This is something that is rampant across. But in a profession such as yours, which is clearly regulated, even the police, I mean, even the medical profession is clearly regulated. There's a way you get licensed, and there are inspections and all. How does this happen?
Sometimes it happens, you have quacks who can fit in within the system. One, if you're lax. Then two, if
When the system is weak.
Yeah, when the system is weak. So definitely we will need to, a Law Society of Kenya, we might need to improve our systems. We might need to improve our systems actually we must improve our systems on identification to build confidence from members of the public that our system is foolproof.
Sure.
Secondly, the platforms are now getting integrated. The immigration practice, it's getting integrated, insurance integrated, conveyancing. Nowadays, you must have an account with the Ministry for Lands, and the judiciary's e-filing system itself. So eventually, with convergence of technology, you will be able then to have only genuine advocates who are practicing. Then the rest, we can then weed them out. Then we also need to enhance surveillance to protect members of the public. No, it's very painful for a person who goes to a quack. You give that quack $500,000 to buy for you land, and then the following day you go back to his office. He's closed up. He's disappeared with your money.
No
It's
longer
very
exists.
painful. So we need to improve. We need to protect members of the public by one, doing proper surveillance and checks. Number two, public information. Like, this is an important forum we are engaging in. The public is able to listen that for you to hire a lawyer, that lawyer must have active status. So everyone who claims to be a lawyer may not necessarily be a lawyer. You must confirm with the Law Society of Kenya. And now we have branches throughout the country. So just go to like in Nakuru, there's a Law Society of Kenya office there. Mombasa, everywhere we have branches. So members of the public should be able to know that please, not everyone who claims to be a lawyer is a lawyer.
Is a lawyer.
Can you can you check with the
advocate?
Absolutely.
Yeah.
Yeah. Well, you don't lose money.
Sure. What recourse can you take, though, however, because there are quite a number of people who've lost millions, especially when it comes to advocates handling the cases whereby an amount of money is supposed to be paid to a large group of people and the money is paid to the offices of the advocate. This happens over and over and over again. So what recourse do you take? Because this is it. Who do you report an advocate?
I think there's a disciplinary mechanism that has been put in place by the Law Society of Kenya.
Yeah.
Remember, if you're an advocate and you receive money on behalf of the public
Clients,
for purposes of a transaction, and then you proceed to actually either use the money and you're reported at the. We have the Advocates Complaint Commission at the State Law Office, and we have the Disciplinary Committee under the Law Society, the Tribunal under the Law Society. These two bodies actually, the members of the public go and report any advocate who has actually committed a professional offense. And that mechanism works because essentially if you give me money for a certain work and I didn't do the work, you have a right as a member of the public to actually report me to those institutions. There are proceedings. You are told to come and defend yourself. If you don't, you're struck out. Or there are three disciplinary measures that have been put in place by the Law Society. Either you're warned, number two, you're suspended for some time, for 2-3 years, or you're struck out of the role of advocates.
Forever, yeah.
Forever. You can't practice
never
within
practice
the space.
again.
Those are the internal mechanisms. In terms of public mechanisms, and I think this is important because it goes beyond the Law Society, we have to look at the judiciary, let them play their part, that anybody who appears before them must actually identify. And I think nowadays there is a face, and even though that is the reason why we are here, someone actually stole someone's identity, I think that is really the much the Law Society could have done at the moment, to put a face and a P105 into the person, so that it's very easy for a judicial officer to actually fact check. It's a simple process to ascertain that the people appearing before me are actually advocates. In terms of transactions and contract writing, these are things that are done in offices.
Yep.
But the consequences come later when there's a dispute as to that. For instance, the purchase of land. If you look at a thrift and the demolitions, you will go, even if you go back, you will find out that the advocate probably who drafted the documents was not a professional, because as a professional you must do due diligence, and one of the due diligence is to find out whether this is actually public land that you're purchasing. Those are basic things, and I think as Peter said, the public assumes that any person, as long as a number has been shared to me, is a lawyer. You assume they are lawyers. You give them assignments, which assignments obviously will have an effect later on. If it was an advocate who committed that offense, and I can tell you right now, that offense of actually overseeing a transaction which was on public land, the Law Society of Kenya alone, that advocate is liable individually for committing the offense. He did not do due diligence to actually advise their clients accordingly that this is public land.
How often are lawyers arrested over such offenses?
Actually, they are arrested all the time. There are serious matters before superior courts where lawyers were actually...
How many lawyers are arrested over such offenses?
Let me say something here. You know, what he raised was a fundamental issue. There's a difference between a quack committing a crime as purporting to be a qualified person, and a real advocate, qualified, committing a crime. So it happens. Sometimes there are cases where a qualified advocate handles clients' money, and then that advocate misappropriates clients' money. So then, what are the remedies for that particular client? I believe that's what you wanted to find out. So the remedy, as Mr. Mana has said, is that members of the public need to know that the legal profession in Kenya is regulated. No one, even if you are an advocate, you can get away with committing a crime. What happens is that we have the Advocates Disciplinary Tribunal, where an advocate who has committed a crime, apart from being arrested by the police and charged in court, because you know you can be arrested if you steal clients' money, you'll be arrested for theft and taken to court. Then you are taken to jail as an advocate. Apart from that, then you also have the advocate's disciplinary process. That process you are subjected through. You are prosecuted by Law Society of Kenya through that tribunal, and then when you are found guilty, depending on the level of offense, some offences may be minor, so they can say we suspend you from the role of advocate for 5 years. Others are serious, like theft of funds. If you steal clients' money and you are an advocate, you will be struck off. Struck off means you will never qualify as an advocate. Never practice again. And members of the public also need to check with the LSK, because there's that database. If you have been struck out. And LSK usually publishes this in the Kenya Gazette. So what we need to do is maybe tell members of the public in a more robust manner that so and so is no longer an advocate. Don't trust him with
in the Gazette
with transactions. So we need more public information. We need to educate members of the public about the legal profession. The other mechanism is under the Advocates Complaints Commission. It's at the AG's office. If a lawyer has misappropriated your money and you have a complaint, the legal sector is well regulated. It is checked. Just go to any Attorney General's office in any part of the republic. They will advise you that if you have a complaint, go put it in writing. We'll forward it to the Advocates Complaints Commission. And most of these complaints which are taken to the Advocates Complaints Commission and the Advocates Disciplinary Tribunal, if you're a lawyer, you usually attempt to settle them because they are serious. It's taking away your bread. That means you must settle. You must settle that issue. If it's money, you must really refund. So the legal sector, members of the public need to know, is really regulated. It's a legal sector where there are no quacks.